Hello, guys. Hello, friends. I'm so excited to come your way. I am spilling some hot U.S. immigration law tea. I hope you guys are doing great. Uh-uh. I have just been brewing this tea, brewing and just soaking in all the aroma just to be able to give you all the legal tea. So something really exciting happened a couple of days ago. There was a Supreme Court decision, Sanchez Sanchez v. Mayorkas, who is the Secretary of Homeland Security. So we're going to be going into the juice and the tea of the case. I have the entire case. I've read it multiple times through and through. I've listened to the oral argument that happened at the Supreme Court. Just pure excitement. I mean, it was just I was just so I was really happy to hear the rich arguments from both sides, and then the justices elicit arguments and ask questions, and the attorney for Sanchez had to defend her position, and the DHS also had to defend their position and all of that. So we have the decision right here, and we're going to be going through this decision and what it means for you know for certain types of immigrants in U.S. immigration law. All right, guys. So please stick with me, and then let's get into it. Okay, so we'll just go into the tea of the case. All right, yep, right here. I found it. I've, of course, highlighted all the relevant parts. And guys, let me tell you, I have actually almost highlighted the entire case because where I'm like, okay, I'm going to highlight what is relevant for the discussion, and I'm just reading in everything is relevant. I'm like, oh my goodness, I've painted the whole thing yellow. So I'm going to try to keep it as crisp and as short as possible. Okay, guys. So this was again in the Supreme Court, and so the petitioner of the case is known as Sanchez. He's Jose Sanchez, and he entered the U.S. unlawfully from El Salvador. When it says unlawfully, I mean, you know what that means. It means he didn't come through a port of entry. So, for example, through the airport where he had a visa and then was inspected and admitted. Okay, so let me while we discuss the case, I'm going to be discussing certain aspects, and then in a hope that you'll understand better what all of this means. So when you look on a charging document, an NTA, a notice to appear, that is the I-862, the document that actually brings an alien before an immigration court, and then deportation proceedings are commenced against him. There are three types of entries. Okay, so we have the if you are admitted. Admitted means you have been, of course, admitted and inspected. So that's lawful admission. You came through a port of entry. Let's say you had a B1 or a B2 visa, and then you were questioned at the port of entry or at the border or the customs. You know, when you get to the airport, what's called the customs. You were asked, what's your name? What are you coming to do here? That is the inspection. And then after that, you are authorized to come into the United States. Okay, you cross that door into the beautiful country of the United States. That's lawful admission. And then you have the EWI. That's entry without inspection. I'm laughing because EWI also is a word in my local language, Iwi, and then it means you're a thief. So it's kind of interesting. So the EWI people, aliens who are not admitted or paroled. And then we have the arriving aliens, people who came in unlawfully but were, sort of apprehended, and then they were allowed in. Okay, so those are some of the categories of entering into the United States. So let's get into the case. So right here, so Sanchez came in unlawfully from El Salvador, And years later, of course, because of unsafe living conditions in that country, the United States granted temporary protected status. And this would entitle, if you are granted temporary protected status because your country is unsafe, or there's some unsafe living conditions, or there's some issues with the country, the safety of the country, then you will be entitled or allowed to stay in the US and to work for as long as the country conditions persist and it's unsafe to actually deport you or send you back. Okay, so usually there are two types of TPS. The first type is people, for example, you've come on a B1 or a B2 visa, and let's even make it three types. You've come on a B1, B2 visa. The visa is still valid, and then your country is designated by the DHS that, hey, your country is a TPS country, so it means that it's unsafe to go back. So if you want, you can, of course, we're not going to deport you even if your authorized stay expires. Okay, so you can get authorization to stay in the US through that. And then for people who came in lawfully, let's say with a visa, a B1 or a B2 or an F1, and then they allowed their visas to they no longer have authorization because their visas ended or the period of authorized stay ended. Okay, and so those kinds of people can also get TPS status, of course, if they apply for it. And then we have the people who came in unlawfully. So the first two types of people would have been said to be lawfully inspected and admitted into the US. But if you came in unlawfully and your country is still designated a TPS country, then you can still get TPS status, because TPS, the provision, the INE section that actually grants the TPS status doesn't make it a requirement to actually enter the country lawfully to become a TPS, to get the TPS status. Okay, so you don't need lawful admission to actually get a TPS status. So let's continue. So the question, guys, let me pause here and then tell you something Justice Breyer said, during the Supreme Court oral argument. He said, I have to admit the immigration statute is pretty complicated. This gives me so much pleasure. Yes, it is really complicated, and I'm happy that even a justice of the Supreme Court admits it. I mean, anyway, don't let me ramble on. Let's continue. So, guys, the question here is that Sanchez now wishes to become a green card holder, what is known technically in U.S. immigration law as a lawful permanent resident. And so the question is whether the conferral of TPS would enable him to obtain a green card despite his unlawful entry. So guys, take note that unlawful entry can allow you to get TPS status. But the question here is whether the unlawful entry can allow you to get something more than TPS status, which is a green card. Okay, so that's the inquiry in this whole matter. Okay, so the relevant section is the U.S.A. section 1255. Okay, the United States Code section 1255. Okay, so let's go down. Let me pull my screen is okay right here. So under that section, okay, under that section, a non-immigrant's eligibility for an adjustment of status, of course, green card, depends on admission. Okay, so under section 1255 of the INA, your status, where's my laws are right here. Let me pull this up. Under section 1255, your admission depends. Your being able to get a green card actually depends on your lawful admission. That's basically what the section says. Let me see if I can pull this up right here quickly. Yeah, I may be able to pull it up. So an admission is also defined as the lawful entry of the alien into the United States after inspection and authorization by an immigration officer. Okay. So guys, that's what lawful inspection is. And so if you come in without being inspected and authorized, then unfortunately it becomes a challenge trying to adjust your status to become a green card holder. I'm finding it difficult pulling that up. Let's continue. All the laws have been defined right here for us, so that shouldn't be a problem. All the statutes have been quoted. So right here, back here. Okay, so the admission lawful entry. So lawful entry requirement appears in two pertinent provisions of Section 1255. One states that a non-immigrant may become a green card holder or an LPR only after he has been inspected and admitted, or he has been paroled. So a parole is a document that allows you to come into the country. Okay, so that's clearly distinct from being inspected and admitted. And another section also states that a non-immigrant who has previously worked without authorization in the United States may become a green card holder only if his presence here is pursuant to a lawful admission. Okay, so guys, let me backtrack a little bit. You can divide types of people here in the US, into four groups under US immigration law. You have the US citizens, you have green card holders, you have non-immigrants, and then you have, the other groups of people who are undocumented. So non-immigrants are people who are here, for example, on F1 visa, K1 fiancé visa, B1 visa, B2 visa. F1 is the student, B1, B2, B1 business, B2 tourist or visitors visa, and then K1, as I said, the fiancé visa. Okay, so those are the non-immigrant visas, meaning they don't want to come. They are just here. They've been granted authorization, a temporary authorization to be in the United States, say for 6 months or however long. Okay, so that's why the section is saying that a non-immigrant can only get a green card only if he has been inspected and admitted or paroled into the United States. So a separate provision of immigration law establishes the TPS program, and this provides humanitarian relief, as we said, for foreign nationals who are in the US who came from specified countries. So currently, to the last country that was designated a temporary protected status country was Haiti. This was on May 22nd. Okay, Haiti was designated, and currently we have countries like El Salvador, Honduras, and African countries like Sudan, Rwanda, Liberia, Sierra Leone. All these countries are TPS designated countries. So the people who come from those countries who are here in the United States, have the TP can apply and then be granted the TPS status. So the Haiti one, for instance, that was just granted on May 22nd, Haiti has been designated a TPS status, a TPS country for 18 months. And so you'll be given that period of time to work and live here. And then the DHS can decide to extend the time or whatever. Okay, so the government may designate a country for the program when it is beset by especially bad or dangerous conditions, such as arise from natural disasters or armed conflicts. All right, guys, still spilling the tea. So, the country's citizens, if already present in the United States, may then obtain temporary protected status, TPS. That status protects them from removal and authorizes them to work here for as long as the TPS designation lasts. Okay, so there'll be, as I said, there'll be a period, and then you can live and work here for as long as that designation would last. I'm sorry, that's my phone blowing up. So let's continue. For the purposes of adjustment of status under Section 1255, a person given TPS shall be considered as being in and maintaining lawful status as a non-immigrant. Okay, so this is particularly interesting. What the TP so there's a when we say that somebody is in like maintaining lawful status, it's actually very relevant because you generally cannot adjust your status if you are out of status. Of course, there's an exception with, immediate relative, people who are beneficiaries of petitioners who are immediate relative, immediate relatives. So I don't want to go into the exceptions, but for example, people who are applying under VAWA, they can be out of status and adjust. So if you are also the spouse of a U.S. citizen, you can be out of status and adjust. You see, so there are some exceptions to the general rule, but generally, you cannot adjust your status under Section 1255 of the Immigration and Nationality Act. You cannot adjust your status if you are out of status. So what the TPS designation does is that it's actually conferring lawful status on these people. Okay, so let's take a look. Where were we talking too much? I've just lost. Okay, right here. Yes, so TPS will actually put you into a status of, into a lawful status as a non-immigrant. Okay, so you can maintain lawful status as a TPS holder while your country is designated and you have applied and you have been approved because of TPS. You will not be deemed to be out of status or in unlawful status. Okay, that's what it simply means, which is a good thing. So we'll get a little bit into that later. Let's just continue. Let's get into the story. This is the real tea, guys, the story of Sanchez. Let's find out, how he came here, what happened. So Sanchez came into the US in 1997, which is over 20 years ago, without inspection and without authorization by an immigration officer. Okay. And then once here, he also worked without legal authorization. And in 2001, which was roughly about 4 years after Sanchez came into the US unlawfully, the government designated El Salvador under the TPS program, when they had some earthquakes. So Sanchez obtained TPS that year and has held it ever since. So in 2014, that's when the first application happened. He actually applied to adjust his status, based on employment. Okay, that was what happened. He tried to adjust his status based on employment. And then when he filed that application, U.S.A denied it. Then Sanchez challenged the application. Then the district court granted it and said, the U.S.A was wrong. And then the Court of Appeal for Third Circuit reversed it. And there was a circuit split over whether TPS entering unlawfully can still become a lawful permanent resident or a green card holder. Okay, that's been the trajectory of the case. Not to bore you, so I've just summarized that part very quickly. Let's continue right here. Okay, so before we get into what actually happened, let me also backtrack and then tell you, give you a little bit of background. So Sanchez v. Mayorkas. Mayorkas is actually the Secretary of Homeland Security. And the, DHS, Department of Homeland Security, is actually a part of the USCIS, and it provides through the USCIS provides immigration benefits to people who are entitled to stay in the US on a temporary or a permanent basis. Okay, and then let's take a look at why this case is against Mayorkas. Okay, so DHS, according to the Immigration and Courts Practice Manual, they are responsible for enforcing, Department of Homeland Security is responsible for enforcing immigration laws and administering immigration and naturalization benefits to people who are in the United States. Okay, And then notes that by contrast, the Immigration Court and the Board of Immigration Appeals, they are responsible for independently adjudicating cases under immigration law. So the DHS is entirely separate from the Department of Justice and the EOIR, the Executive of Immigration Review, in proceedings before the Immigration Court or Board. Okay, so the DHS is deemed to be a party and is represented by its own attorneys. That's why you have Sanchez versus Mayorkas. So DHS was actually created in 2003, and prior to the creation of the DHS, it was the Immigration and Naturalization Services, the INS. That was the body that was responsible for enforcing immigration laws and administering immigration naturalization benefits. And at the time, INS was a component of the Department of Justice. And so what happened was INS was abolished, and the role was now assumed by the DHS, which is entirely separate from Department of Justice. Okay, so what they wanted to do was actually separate DHS from the Department of Justice so that DHS can sort of be, independent, so to speak, so that because the Department of Justice, the courts are under the Department of Justice. So just to avoid a conflict of interest, DHS was now created and then entirely separated from the Department of Justice to give it that kind of independence. Okay, so that's the background. Let's continue. So essentially, let's see. Okay, so I mentioned the circuit split, that was, whether the TPS people who entered unlawfully could still become green card holders. And the Supreme Court granted certiorari to resolve the circuit split. Okay, and then they affirmed the Third Circuit's decision that he cannot. So Sanchez could not become a green card holder simply because he did not enter the US lawfully. That was Sanchez's mistake and his biggest headache ever. So the conferral of TPS status does not make an unlawful entrant eligible under 1255 for adjustment to LPR status. So let me read section 1255 of the INA, the Immigration Nationality Act, and then we can. So section 1255 actually covers adjustment of status of non-immigrant to that of person admitted for permanent residence. So it simply means that 1255 covers adjustment of status from non-immigrants to green card holder. Okay, it's quite a long text. So it basically just says that the status of an alien who was inspected and admitted or paroled into the US may be adjusted by the Attorney General in his discretion. That's what A says. And then C actually gives the exceptions, people whose status may not be adjusted, even though they have been. So the main focus of this is A, because it only gives, the provision only covers that the Attorney General would allow aliens who have been inspected and admitted to actually have their status adjusted. That means that if you have not been lawfully inspected and admitted, then you are out of the purview of the statute. And so that's what the whole thing boils down to. And let's see if we have something here. Okay, so yeah, they just go on to say that the section 1255 imposes an admission requirement twice over. Okay, that you should have been inspected and admitted, and then you should also not have worked without authorization, and you can become an LPR only if your presence is present to a lawful admission. Okay, so the emphasis is right there, lawful admission. Okay, and they're saying that the Supreme Court stated that there's nothing in the conferral of TPS that changes that result. Okay, as noted, a TPS recipient is considered being in and maintaining lawful status as a non-immigrant. So being in lawful status is very different from lawful admission and inspection, or being inspected and then admitted. Those are very distinct concepts, as the U.S. Supreme Court stated. Okay, so for example, you can be in lawful status, but you were not lawfully admitted and inspected. So, for example, you would have somebody who, let's say, jumps the Mexico wall or Mexico border. I'm sorry, the border to come into the United States. They did not come in lawfully. Okay, they were not admitted and inspected. However, if they're able to obtain asylee status later on, so they apply for asylum and then it's granted, then they are said to be in lawful status. However, they were not admitted and inspected. And then oppose that to a student on an F1 visa who comes in through, let's say, the airport, was inspected and then lawfully admitted. When they, so let's say they well, let me say a B2 visa, so tourist, you came in 6 months, and then now you stayed for 2 years. You have stayed beyond your period of authorization. You came in lawfully, however, you are not in lawful status. Okay, so one does not necessarily imply the other. So it says right here that so even though TPS considers, if you're a TPS recipient, you'll be considered to being in and maintaining lawful status, it doesn't change the fact that your entry from the beginning was illegal. Nothing changes that fact. Okay, that provision ensures that in applying for permanent residency, a TPS recipient will be treated as having non-immigrant status, even if, like Sanchez, really does not. Okay, so yeah, so basically, they also went on to say that the provision doesn't help TPS recipients in maintaining Section 1255's independent legal entry requirement. So there is an independent legal entry requirement that states that, look, the Attorney General in his discretion can adjust the status of any person who came into the United States lawfully and was admitted. Okay, so you have to have come in and been inspected and lawfully admitted. Okay, that's the legal entry requirement. The lawful status and admission, as the court below. Okay, so lawful status and then lawful admission are distinct concepts in U.S. immigration law. Establishing one does not necessarily establish the other. Okay, so let me scroll down. We're almost through right here. Yep. Okay, let me give this example again. So the Supreme Court gave this example of, think of somebody who's like a student, okay, came in on a student visa, but stayed in the country, in the US, long past graduation. On the other hand, a foreign national can be, so when you come in legally and then you stay long past your graduation as a student on a student visa, you actually came in lawfully. You were admitted, however, you're not in lawful status because you are no longer authorized to be on United States soil. Your permission, there's no longer any permission to be right here because you came in for the purpose of studying. Graduation is over. What are you still doing here? Okay, so on the other hand, a foreign national can be in lawful status but not admitted. Again, think about, yeah, what I said, asylum. If you receive asylum, then you are in lawful status, okay, and you enter the country lawfully. You're in lawful status, but you didn't enter the country lawfully. Still spilling this U.S. immigration law tea. All right, guys, so let's continue. We're almost at the end. So the statute, the TPS statute permits somebody like Sanchez, okay, it permits him to remain in the country, even though he came in unlawfully, and it deems him in non-immigrant status for the purposes of applying to become a green card holder. But the status does not constructively admit a TPS recipient. So admission here is a technical term. It doesn't admit because the point of admission is actually to have gone through some inspection and admission, subsequent admission at a port of entry. The TPS recipient of a TPS status doesn't get that. Okay, so Sanchez came in unlawfully, and unfortunately, the TPS didn't grant him, legal entry. And because of a TPS does not, because of a grant of a TPS does not come with a ticket of admission, it does not eliminate the disqualifying effect of an unlawful entry. Sanchez resists this conclusion, and he asserts the insoluble relationship between admission and non-immigrant status. Sanchez's attorney, she put up a good show. She put up a really, she was persuasive, and she put up a good fight for her client. Unfortunately, it didn't work out. She was asserting that yes, the fact that Sanchez has been granted status. So the fact that Sanchez is now in lawful status presupposes or inherently carries within it a lawful admission, and the court said no, those are very distinct. She was now actually sort of advocating that there was an indissoluble relationship between admission and non-immigrant status, because now Sanchez has been granted non-immigrant status. He is in lawful status, because of the TPS. But the Supreme Court said no, admission is different, non-immigrant status is different. The fact that we've granted him protection and given him he's in lawful status now does not mean he was admitted. Doesn't mean that. Okay, so one cannot obtain. Okay, so Sanchez was claiming, one cannot obtain lawful non-immigrant status without admission, which may not necessarily be true. I see where her point is. That just because you've been granted lawful non-immigrant status, then you've been admitted. But the admission is actually, a physical act. It's an act of actually being inspected and admitted, and nothing can constructively admit a non-immigrant into that kind of status. Okay, so that's it. And he has said that it's impossible to identify any category of individuals. No.